Nsem-Pii TV nie.
Jamo akwa babiem edeba Nsem-Pii TV platform yi eso. Awia idea the Honorable Chief Justice, a Ladyship Justice Gertrude Isaba Saki Tokonu and Enijie Akwakopiemu Ewana Shue. John Dramani Mahama, the president, and the NDC. Omo evil agenda, omo woditiano, and a host of judges across the length and breadth of Ghana. And she said, no crenu na babe dedicate tiamo. Say she say ya omo share nyina ayekwa. Susu omo susu omo trimu nyina ayekwa. John Dramani Mahama nsem oduko tujwa wo NDC Professionals Forum. Say omo aba ban mu de, omo lawyer for no obese so bebre akwa kugu. Ye bench no so wan be judges no. E say ya be todwa mu bi ehu. Na most importantly, any say ni the Council of States, a very long-standing member of the Council of State. Your friend is a lawyer Sam Okudzeto. Sa papa yi ono na ye de ne to ye Samuel Okudzeto abala kwa north to no MP. Samuel Okudzeto ye lawyer ni awagidi yi Ghana haye pa. Obo Sam Okudzeto an associate dia. And just one of the leading firms in Africa and the entire world. I don't know say Council of State ni mapano dia babetu dia say Council of State Intiminisia. Later now, John Dramani Mahama ma Felix Kwachofu su de beto abonten say Council of State international no manya nhwemu. O se senhia mu di nankasa. Enya de be yaduma, enya de betimi abaso. Isan say senhia mu di no etiamra. Ono Council of State no or your member pay. Now, BBC eba the first thing that was Udikanye as president, and he said you have to inform the Chief Justice. John Mahama ain't inform Chief Justice Tokono, as rightly captured in a letter. Chief Justice Beto Abonti and report to the man. To essential Mudino Council of State Entiminsia and Dream BBA home and Mekanchre Ghana for so my determination be I establish a premier fashion. I was say you call the next step, take committee, Emma committee no, a secret meeting. Na omodifishemu sa ansem no. Number 2, or say petitions here professors ahodo emode akwa dan John Dramani Mahama onam koti kwan so one much just so antia or person ka Council of State transia ene omuntumi transia no. Sebi. Nyan sakitikiti say ba kokrani in his own words or say it lacks legal sense. Na ono petitions ahodo bebre sa aba beto ne nsa. And the chance of Council of State in Swa, you will legal committee. I don't know a chairman no danwa. Sanseme buying now, one was almost shess, legal committee in Puna also the country. Now, more lawyers, almost young Ranacho, Munim do or more make determination into a mokra good case no one. Nyadia Council of State in Posevet Nasaba Union Biaho. Now, correfe, Ediama president, be my president, Aquatic committee, I'm Yakoshemu. Ama nkamia ese ya bi Chief Justice Eddie Free hono na lawyer Samuel Okudzeto wakasa yie pa obi efunu nani ani amene obi ehunu se John Dramani Mahama ne bi NDC ye nyina omu ne nyina so bia otan hunu keke ena omo di time the leadership Justice Sakito Kono yentie se de lawyer Samuel Okudzeto former Council of State member usidi nsem no atudwa.
Lawyer Samuel Okudzeto, he used to be the former chairman of the Council of State. I'm grateful to you, sir, for joining us here. Now, you've been at the Council of State before and you are a lawyer too, so you can give us this education. When the petition gets to the president, what that should the president really do?
Well, first of all, you say I'm chairman. I was not chairman of the Council of State. I was the chairman of the Legal, Constitutional and Petitions Committee of the Council of State.
Thanks for the correction, sir. Yeah.
And so, if there is any issue in relation to what you are discussing right now, it directly involves the position that I did occupy.
Yes. So, I mean, this is a legal matter, and because you've been there before, you can rightly educate us, and that's what I wanted to find out from you. When such petitions get to the president, what must the president do? The
president ought to be able to inform the not able. he must inform the Chief Justice and get the Chief Justice's reaction. It is that reaction, together with the petition, that he consults with the Council of State. And therefore, whether there is a prima facie case made or not, they will decide together. And let me also say that I have had an experience of that where petition was sent, and that petition was accompanied by a huge volume of documents that the Chief Justice's reaction. And that formed the basis for which we, as a committee and the council, took a decision that the petition was frivolous.
So,
because no prima facie case was made.
Okay. Because when you consulted the CJ, you realized that there was no prima facie case?
We did not consult with the CJ. Let's get it clear. I said she responded with a voluminous documents and explanations and procedures and processes that the petitioner completely is ignorant about. And that formed the basis for us to come to the conclusion that no prima facie case has been made.
When you read the Constitution for the layperson, it doesn't come across as though she has to be given that hearing before. But she's also writing that per the rule of natural justice, she had to be heard. So in this case, now that the petition has been forwarded to the Council of State, what happens then?
The Council cannot consider that petition without hearing from the Chief Justice. Upon what will be the basis for their decision? If they make allegation against the person, you didn't hear from the person, what would be the basis for your conclusion that you reach as whether a prima facie case has been made or not? A simple logic.
Now, we know that when the president really gets this petition, in consultation of the Council of State, must appoint a committee consisting of 2 justices.
No, you are getting it wrong. You are getting it wrong. You are getting it wrong. It is only when the president and the council has come to the conclusion that there was a prima facie case that they can refer it.
Okay. So it means the CJ has a point that she has to be heard before.
She's right, because I was telling you that we have done it before. The president there.
Okay. Interesting. So now that the case, there's been 2 suits filed at the Supreme Court against the AG on this particular matter. She is the one who has to then appoint justices to sit on this matter, right?
But they knew it. They know that is her right.
So
the Constitution does not give that power to anybody else. That's the more reason why sometimes we should be a little careful. And let me also just emphasize that this thing should not have been publicized.
Okay.
That when I was on the Council of State, we felt that it was a wrong thing to do. That when a petition of that nature comes to the president and sent to the Council of State, it should not have been publicized.
Okay.
It is only when the council and the president come to the conclusion that a prima facie case has been made that publicity can be given to it. I think it's a wrong approach.
So will the president and the Council of State be acting illegally if they should proceed without doing according what she's asking for? That she's asking to be finished.
No. This is. I'm saying that it's not only law; it's also simple common sense. Is to say that on what basis is the Council of State and the president going to say that a prima facie case has been made when they have not heard from the person who is accused?
Grateful State, would you expect the Council of State to proceed moving forward?
Well, I've just explained to you. I disagree with the professor because his interpretation to me makes no legal sense. Why would there be a provision that protects judges or superior courts which does not protect the Chief Justice? And I'm telling you that even your conclusion about Akufo-Addo issue is also incomplete.
Okay.
I was the man and I wrote that opinion. And I am saying that between us and the president, we came to the conclusion that no prima facie case was made. Therefore, we dismissed the petition. As president, of which I was involved, I was the one who wrote it. And I'm saying that it is just simple common sense in legal interpretation. That you say that if something can apply to this, the same thing should apply to something else.
All right.
The Chief Justice is not occupying an inferior position to judges of the Court of Appeal
Okay.
or the Supreme Court. She does not. She is also a Supreme Court judge, and at the same time, the Chief Justice. So, a more rigorous application of the rules must apply to her. And so, you cannot say that because there was no provision in the Constitution. Constitution has to be interpreted in its broader context. It is not just words that we interpret Constitution. When you want to interpret the Constitution, you must take it and say, what is the intention behind what is written in the Constitution? That is the way to interpret it. You don't just take words.
Of me, let me bring in another lawyer, Professor Kojo Appiah. He is Associate Professor, School of Law, University of Ghana, and a human rights lawyer. Grateful for joining us. Now, the Chief Justice says, I have to be heard in this matter, even before the President determines a prima facie case. Is she right?
Well, we have to look at thanks for having me in the first place. We have to look at the issue from the constitutional angle. If you look at the Constitution carefully, Article 466 says that the President shall refer such a petition to the Council of States for consultation. And then, based on the decision or the advice of the Council of State, a committee will be set up. So, but if you look at the process for other justices of the Supreme Court, it says the matter will refer to the Chief Justice, and based on a prima facie conclusion, then the Chief Justice will go ahead and set up a committee. So you can see that the two processes are different on the face of it. So if there's a need for a prima facie case, then it means that the other party should be heard before a prima facie conclusion can come to. Then the committee will go into the matter full time in the fullness of it. But with respect to the Chief Justice, 1466 is saying that after the consultation, a committee will be set up. So you see the omission of prima facie case. So there can be two ways of looking at it. One is that it means that it doesn't completely deprive the Chief Justice of the opportunity to be heard in this case. But it is only at the stage where the committee is set up that the Chief Justice will have that opportunity. So the rules of natural justice is not completely denied the Chief Justice in this case. On the other hand, the interpretation that the Chief Justice herself and those petitions that have been cases that have been brought to the Supreme Court asking for injunction is that the prima facie option should also be given the Chief Justice, so that the Chief Justice will have the opportunity to know what the petition contains and respond to that, and that should go to the Council of State to make its decision. But the rules, the Constitution itself is not clear. The same thing applies with regard to the appointment of the Chief Justice. The rules are different from the Chief Justice as regards to the other justices of the Supreme Court. So I think probably in the view of the framers of the Constitution, they wanted to set up different conditions for the Chief Justice and the other justices of the Supreme Court. But if you look at the rules of natural justice, the Chief Justice may be right in demanding it at this stage before it goes to the Council of State, but it doesn't completely deprive her of the opportunity to have her case heard at the committee level, or at the committee that will be set up in case the Council of State concludes that a prima facie the case should be referred to the committee.
Now she says, and I quote, respectively, in the case of the Chief Justice, please allow me to submit that it is the combination of the evidence in the petition and the response of the Chief Justice that provides the material for consultation between His Excellency the President and the eminent members of the Council of State under Article 1466. These two sources serve to guide whether a prima facie case has been established, such that a committee of inquiry should be set up under Article 146 to inquire into whether the Chief Justice should be removed from office. That's a case. Now you need to listen to me and add it to the consultation you have before you can establish. Those two would help you establish whether there's even a case in it after all.
That's what I'm saying. That in this case, if you read the Constitution carefully, 1466 does not talk about prima facie case being established before the matter will go to the Council of State. So reading the black and white letter of the Constitution clearly does not give that provision or make that provision available to the Chief Justice.
But then she cites the Ejechin versus Attorney General and Akwete 205 says that what she said is the direction the Supreme Court gave in that particular case. That's her reference.
Yes. And in that case, I'm not sure it directly touches on the Chief Justice, but I could be wrong. But I think it's referring to justices of the Supreme Court. So that is where the prima facie case comes in, and that is the same argument she's also making, that she should also be considered as she's a part of or a member of the Supreme Court, and so that same rule should apply to her. And in law, there can be the situation where you say that there could be an omission in one part of the law, but if you look at another part of the law, it can be used to cover that omission. And I think that's the argument that the Chief Justice is making. So in that case, she's saying that let's take things slowly. Let the rules of natural justice apply, and let us see what the response will be. But we may also want to refer to the petition by Professor Asare last year that the Chief Justice should be removed. I don't recollect the facts very well, but in that case, the then President Akufo-Addo dismissed the petition. But we didn't see a situation where there was a call for a prima facie case, and the matter died a natural death.
Okay.
So, looking at the steps that President Akufo-Addo took, it means that there was no call for prima facie case when the petition was brought before the President.
Okay. All right.
Yes.
I'm grateful to you, sir. Professor Kojo Appiah there. Let me bring in Samuel Okudzeto again. So, how do you expect the Council of State to proceed moving forward?
Well, I've just explained to you that I disagree with the professor because his interpretation to me makes no legal sense. Why would there be a provision that protects judges or superior courts which does not protect the Chief Justice? And I'm telling you that even your conclusion about Akufo-Addo issue is also incomplete.
Okay.
I was the man and I wrote that opinion. And I am saying that between us and the President, we came to the conclusion that no prima facie case was made. Therefore, we dismissed the petition. As President, of which I was involved, I was the one who wrote it. And I'm saying that it is just simple common sense in legal interpretation that you say that if something can apply to this, the same thing should apply to something else.
All right.
The Chief Justice is not occupying an inferior position to judges of the Court of Appeal or the Supreme Court. She does not. She is also a Supreme Court judge, and at the same time, the Chief Justice. So, a more rigorous application of the rules must apply to her. And so, you cannot say that because there was no provision in the Constitution. Constitution has to be interpreted in its broader context. It is not just words that we interpret Constitution. When you want to interpret the Constitution, you must take it and say, what is the intention behind what is written in the Constitution? That is the way to interpret it. You don't just take words.
Okay. All right. I'm grateful to you, sir, for joining us with this education. Let me go back to Parliament and bring in our legal affairs correspondent, Kwekwa Asante. We understand that a date has been set for the hearing of the injunction application against the processors to remove the Chief Justice. Kweku, what more do we know?
Yes, Brace, the process is moving quite expeditiously. We know that the action filed by lawyers for a conviction, as it was led by Godfrey Dame, was filed at the Supreme Court Registry at about 9:35 a.m. this morning. We understand the Supreme Court will now hear the action. The next available day, which will be Wednesday, 2nd April at 9 o'clock a.m., the Supreme Court will hear the injunction application that has been filed by Nsem-Pii, who are seeking to injunct the process for moving ahead for the Chief Justice to be removed, the process leading to the removal of the Chief Justice. He has filed for an injunction application, and now the court is set to hear that application on Wednesday, 2nd April at 9 o'clock a.m. Brace.
Okay.
Now share on my YouTube channel.
Be the first to know Nsem-Pii TV.